Generally, a state court or federal district court sitting in diversity may exercise personal jurisdiction over a party if doing so is authorized by state law and permissible under the Due Process Clause of the Fourteenth Amendment. When it comes to specific jurisdiction, which is personal jurisdiction based on the defendant's activities in a state, due process requires that the defendant has minimum contacts with the forum state such that exercising jurisdiction wouldn't violate traditional notions of fair play and substantial justice. In Daynard v. Ness, Motley, Loadholt, Richardson, and Poole, the First Circuit considered whether an agent's contacts could be imputed to a non-resident principal for the purposes of exercising personal jurisdiction. Richard Daynard was a law professor in Massachusetts. His studies primarily involved lawsuits against the tobacco industry. The Ness firm, based in South Carolina, was one of multiple firms that represented state governments in lawsuits against the tobacco industry. The Scruggs firm, based in Mississippi, was another such firm. In 1993, Charles Patrick, a partner at the Ness firm, went to Boston to meet with Daynard to retain his services. Patrick explained that the Ness firm and Scruggs firm were engaged in tobacco litigation. Further, Daynard believed that Patrick was acting on behalf of both firms. Daynard claimed that he provided advice to both firms. He further alleged that Scruggs had orally agreed on behalf of both firms to pay him 5% of their attorney's fees in the state tobacco litigation. Neither firm paid Daynard. Accordingly, Daynard sued the Ness firm and one of its partners, whom we'll refer to collectively as Ness, in Massachusetts state court. Daynard sued the Scruggs firm and one of its partners, whom we'll refer to collectively as Scruggs, in the same suit. The defendants successfully removed the case to federal district court. Ness submitted to the court's jurisdiction. Scruggs, however, moved to dismiss for lack of personal jurisdiction. The court granted Scruggs' motion. Daynard appealed to the United States Court of Appeals for the First Circuit.